Harry's new low, a desperate move from the prince. It's being reported that Harry is now literally begging his father, King Charles.
A federal courthouse in Washington, D.C., a judge, a sealed file, and a clock that has been ticking for 6 years. On June 12th, 2,487 pages of sworn federal documentation, signed under oath, filed in the most powerful legal system on earth, are going to be open to the public. And when they are, every carefully constructed wall around one of the most protected men on the planet is coming down with them. Not because of a tabloid tip, not because of a palace insider, not because of a source who once worked near Kensington, because of a form, a government form, and the answers he gave on it. Here's the question I want you to sit with before we go any further. If you had publicly admitted, in writing, under your own name for tens of millions of dollars, to violating federal law on American soil, would you spend 6 years and tens of millions more fighting to keep a government form sealed? Because that's exactly what's been happening. And in a matter of days, we find out why. Stay with me, because by the time this is over, you're going to understand something the mainstream media has been too diplomatically cautious or too commercially compromised to say out loud. This isn't a celebrity story. This isn't a royal family soap opera. This is a federal case, and the man at the center of it has, in his own handwriting, already written his own indictment. Let's go through it. Every document, every date, every dollar, every contradiction. The case that shouldn't exist, but does. Let's start at the beginning, because context matters here. The lawsuit is called Heritage Foundation versus Department of Homeland Security. It was filed in January 2023 after Prince Harry, the Duke of Sussex, sixth in line to the British throne, published a memoir called Spare. Now, Spare is a lot of things. It's a family grievance aired in 416 pages. It's a commercial product that generated an estimated $20 million publishing advance alone. It's a cultural moment that dominated every newspaper, every podcast, every dinner table conversation for months. But legally, and this is the part that matters, Spare is a confession, not a metaphorical confession, not an admission open to interpretation, a written, published, globally distributed, professionally promoted confession to years of illegal drug use. Cocaine, magic mushrooms, marijuana, ayahuasca, in the UK and, critically, on American soil. The Heritage Foundation, a Washington, D.C.-based conservative policy organization, read that book and asked a very simple question. How did a man who confessed to all of that walk through U.S. immigration in 14 days? That question has now spent over 2 years in federal court, and the U.S. government has spent those 2 years doing everything legally possible to prevent the answer from becoming public. Until June 12th. So before we get to the documents, the redactions, the financial contradictions, and the legal exposure, let me explain why the speed of Harry's approval alone should have alarm bells ringing for every single person watching this. 14 days versus 14 months, the number that changes everything. March 2020. Harry and Meghan cross into the United States. They pass background checks, they clear immigration. The whole process, from application to approval, takes roughly 2 weeks. 2 weeks. I need you to hold that number while I tell you about 2 other people. Nigella Lawson, celebrity chef, television personality, global household name. In 2013, during a court proceeding, not a best-selling book, not a 60-minute special, a court proceeding, she admitted under compulsion that she had taken cocaine and marijuana. The following year, she turned up at an American airport to board a flight to Los Angeles. They turned her away at the gate. She spent months fighting through the formal waiver system before she was eventually allowed back into the United States. Months, multiple applications, multiple submissions, the full machinery of U.S. immigration law grinding slowly forward. Pete Doherty, British musician, actual criminal convictions for drug offenses, made it all the way to JFK Airport before being turned around and put back on a plane to London. Now. Harry admitted cocaine use since age 17. Magic mushrooms at a party in Los Angeles, on American soil. Multiple substances across multiple decades, across multiple jurisdictions. Then he put all of it in a book, promoted that book on 5 continents, recorded an audiobook of it in his own voice, gave interviews about it on every major television network in the Western world, and he got through immigration in 14 days. Here is the question I want every single person watching this to answer in the comments right now. Do you believe that's a coincidence? Or do you believe someone made a decision? Because those are the only 2 options, and both of them lead somewhere very uncomfortable. Heritage Foundation attorney Samuel Dewey stood on the courthouse steps and said it without diplomatic softening. If he lied, that gets you deported. People are routinely deported for lying on immigration forms. Routinely. Routinely. That word is doing a lot of heavy lifting, because routinely means that what happened to Nigella Lawson, the months of waiting, the gate refusal, the waiver applications, is the normal experience. It's the baseline. It's what the law says is supposed to happen. Harry's 14 days isn't the baseline. It's the exception. And federal courts have now spent years trying to determine whether that exception was legal, or whether it was special treatment for a very special name. The form, the questions, and the book that answered them. Let's get precise, because precision is what makes this case so extraordinary. The U.S. visa application form, the DS-160, contains 2 questions that are directly relevant here. Question 1. Are you or have you ever been a drug abuser or addict? Question 2. Have you ever violated or engaged in a conspiracy to violate any law relating to controlled substances? Read that second question again, carefully. Not, are you currently violating drug laws? Not, have you violated drug laws in the past 5 years? Not, have you violated drug laws since the age of 21? Have you ever? That's the legal standard. Have you ever, in your entire life, at any point, under any circumstances? Now open spare. Page after page, Harry writes, in his own words, for immense personal profit, about exactly this. He describes cocaine use at a country house shooting weekend as a teenager. He describes marijuana. He describes ayahuasca. And then, in what the Heritage Foundation's legal team called a moment approaching bragging, he describes eating magic mushrooms at a party at Courtney Cox's house in Los Angeles, California. Los Angeles, California, United States of America. He describes the toilet talking to him. He describes the trash can smiling at him. He writes that he'd begun using psychedelics therapeutically, medically. He published this. He sold it. And then he, or someone acting on his behalf, stood in front of a federal immigration form that asked, "Have you ever violated any law relating to controlled substances?" and submitted an answer. The Heritage Foundation filed the logical conclusion of this in their court brief with what I can only describe as prosecutorial precision. I'm paraphrasing here, but the substance is this. Harry, voluntarily and for enormous financial profit, admitted in writing to the elements of any number of controlled substance violations. The memoir is not ambiguous. It is not open to interpretation. It reads, in the words of one legal filing, as though the author was approaching the point of bragging. He didn't just admit it. He sold it. To a publisher. To streaming platforms. To every morning television show that would take him. And then he asked a federal court to give his privacy back. I want you to think about that for a moment. Tell me in the comments, is it possible to sell your story and then legally claim that story is private? Because that is the argument that has been running in a Washington, D.C. courtroom for over 2 years. And on June 12th, a judge is going to give us his answer. The Confession on American Soil, Why This is Different from Teenage Mistakes. A lot of the coverage of this case, and I want to be specific here, because the framing matters, focuses on the teenage drug use. The cocaine at 17 in England. the youthful indiscretion angle, the "this was decades ago in a different country" defense. And I understand why that framing exists, because it's the most sympathetic version of events. It's the one that lets everyone look away and say, well, who among us hasn't made mistakes when we were young? But that framing is doing Harry a legal favor, and it's concealing something that is categorically more serious. There is a distinction in U.S. immigration law, a hard, clear, legally significant distinction between historical drug use that occurred abroad and drug use that occurred inside the United States. Harry's teenage cocaine use in rural England? That falls into the first category. Uncomfortable, legally complicated, but potentially manageable with full disclosure and a formal waiver process. The kind of thing that might take 6 to 18 months to process. The kind of thing that stopped Nigella Lawson at an airport gate. The magic mushrooms at Courtney Cox's house in Los Angeles? That is a Schedule I controlled substance under U.S. federal law. That is a federal crime committed inside the jurisdiction where Harry was asking to live. That is not a historical disclosure problem. That is a current criminal admission, his own, in print, in the exact country whose immigration system he was simultaneously navigating. When Harry stood in front of Question 2 on that DS-160 form in March 2020 and was asked whether he'd ever violated any law relating to controlled substances, the Courtney Cox party wasn't a distant memory. It was recent. It was American. It was the trash can with a face, the toilet talking back, the experience he described as therapeutic and meaningful and worth sharing with millions of paying readers. This was not, to borrow a phrase from the legal filings, a dusty historical question about conduct in a foreign country. This was California. This was federal law. This was his own published account, filed in evidence in his own case. The Heritage Foundation's lawyers were not being sensationalist when they pointed to the memoir as the primary evidence in the case. They were being forensically accurate. He gave them everything they needed. He just charged $28.99 for it first. The financial impossibility, Meghan's words against Harry's declaration. Now we get to the part that I genuinely cannot believe hasn't received more coverage, because this might be the most legally explosive element of the entire case. And I'm going to need you to hold two facts in your head simultaneously, because when they're next to each other, the contradiction is impossible to explain away. Fact 1. In Spare, Harry describes the purchase of the Montecito mansion. His exact words, "So we pulled together a down payment, took out a mortgage, and in July 2020, we moved in." July 2020. Fact 2. Meghan, in an interview with The Cut magazine, said, unprompted, apparently proud of the candor, "We didn't have jobs, so we just were not going to come and see this house. It wasn't possible. It's like when I was younger and you're window shopping. I don't want to go and look at all the things that I can't afford." Window shopping. Can't afford. No jobs. July 2020. The same month they moved into the house. Now. Harry entered the United States in March 2020, 4 months before the mortgage, 4 months before the move. At the exact moment, by Meghan's own words, when they had no jobs, no income sufficient to purchase the property, and were, in her description, teenagers pressing their faces against a shop window. Every U.S. visa application includes financial declarations. Depending on the visa category, applicants must demonstrate that they can support themselves in the United States without becoming a public charge. You're expected to show financial stability, to prove the numbers, to make sworn declarations about your assets, your income, your means. What did Harry declare about his finances in March 2020? At the precise moment his wife was telling journalists she felt like a broke teenager outside a shop window? These two things cannot both be true at the same time. Either Harry declared financial resources he had, in which case, what were those resources, given that 4 months later they were described as unaffordable window shoppers, or he declared financial resources he didn't have. And if he declared financial resources he didn't have, we're no longer talking about a drug disclosure problem. We're talking about material misrepresentation under 18 U.S.C. Section 1001, making false statements to a federal agency. That carries a maximum sentence of 5 years in federal prison, and it creates, independently of anything else in this case, a permanent visa ban under the Immigration and Nationality Act. I want to ask you directly, is it possible for both of these statements, the financial self-sufficiency claimed on a federal application and Meghan's window shopping description, to be simultaneously accurate? Because I've been thinking about it for a long time, and I cannot find the version of events where they're both true. Leave your answer below, because I suspect a lot of you have thoughts about this, and I genuinely want to hear them. The redaction that confesses everything. March 2025. Judge Carl Nichols orders the government to publicly release redacted versions of the documents they've been submitting to him privately throughout the case. The Heritage Foundation receives 82 pages. More than half of everything on those pages is blacked out. Now, redactions are normal in legal proceedings. Sensitive personal information, national security considerations, third-party privacy, all of that is standard and legitimate. But here's what the government argued in one of the brief, visible portions of those 82 pages. They argued to the judge that releasing Harry's records was impossible, because doing so would, and I'm going to paraphrase this closely because the actual language is extraordinary, allow someone with any familiarity with immigration law to determine the Duke's status in the United States. Read that again. Not, it would reveal sensitive personal details. Not, it would endanger national security. Not even, it would embarrass him. It would allow someone with basic immigration knowledge to immediately identify what visa status he holds. The status itself would tell the story. So let's think about what statuses are available. What are the options? Option 1. A standard O1 visa for individuals with extraordinary ability, combined with a full drug waiver for his admitted history. Processing time under normal circumstances, 6 to 18 months. Harry got through in 14 days. Option 2. A spousal visa tied to Meghan's status, with a drug waiver attached. Also months. Also not 14 days. Option 3. An A1 diplomatic visa, reserved for working royals, heads of state, official government representatives, a status that bypasses drug screening questions entirely. Processing time, very fast. And here's where it gets significant. Harry had, at that precise moment in March 2020, publicly, formally, and permanently resigned from every royal duty he held. He'd stepped back from the institution. He'd given speeches about financial independence. He'd traded the working royal title for a California zip code and a Netflix deal. But an A1 diplomatic visa is issued to working royals, to people who represent the crown in an official capacity. If Harry entered on an A1 diplomatic visa, he used a title and a status he had just publicly abandoned. In his own words, in Meghan's words, in the palace's official statements, to skip a queue that had stopped Nigella Lawson dead at a departure gate. That's not just hypocrisy. That's not just irony. It's using the monarchy as a loophole while simultaneously selling a $60 million content franchise about escaping it. Mike Howell at the Heritage Foundation has been direct about what he believes the delays represent. The documents were originally due in March 2026. The government missed that deadline. The new date, June 12th, falls conveniently after King Charles III's state visit to the United States in late April 2026. After the state dinner, after the bipartisan standing ovation, after Trump received the HMS Belfast Bell and shook Charles's hand, after the whiskey tariffs between Scotland and Kentucky were lifted, after the monarchy got its diplomatic moment on American soil, and Harry's documents got scheduled for after-curtain call. That sequencing is either the most spectacular coincidence in recent legal history, or it's a deliberate choice. What do you think it is? Tell me below. the $135 million privacy claim and why it doesn't work. Let's talk about the argument Harry has been making in court, because it's important to understand it fully, both on its own terms and in the context of everything else. The core of his position, broadly stated, is this: his immigration records are private. The government should not be compelled to release them. His personal history is his own, and disclosing the mechanics of how he entered the United States violates his right to privacy. That is a real legal argument. Privacy interests in government records are real. They exist. They are protected. But the Heritage Foundation's legal team has constructed a response to that argument that is, I'll say it, genuinely difficult to counter. Their position, again broadly stated: Harry has sold every private detail of his life for what multiple analyses estimate at over $135 million. He sold his drug use. He sold his childhood. He sold his grief. He sold his marriage. He sold his relationship with his brother. He sold his view of his father. He sold it to publishers, to streamers, to documentary makers, to morning television anchors, to glossy magazine editors on 2 continents. He sold all of it, voluntarily, for enormous personal profit. And having sold it, having made it public, having made it commercial, having made it a global content franchise, he is now asking a federal court to treat the exact same history as private when the government wants to examine how it interacted with federal immigration law. The Heritage Foundation's filing put it with a precision I genuinely can't improve upon. The Duke of Sussex has sold every aspect of his private life for, in some estimates, over $135 million. His claims of privacy interests in the face of this conduct have been met with widespread public ridicule. The Duke of Sussex must take the good with the bad. Take the good with the bad. He took the publishing advance. He took the Netflix deal. He took the Spotify deal, before they terminated it, and an executive called him something I can't repeat on this channel. He took the 60 Minutes interview. He took the ITV sit-down. He took the global book tour. He took the audiobook deal. He took every single dollar that was attached to the story of who he is and what he's done. And now, when a federal judge wants to look at the government form that was supposed to disclose the exact same history he turned into a content empire, suddenly it's private. You can't sell the story and then sue to keep the story sealed. You can try. You can try for 6 years with the best lawyers money can buy. But you cannot win that argument. Not forever. Not against a deadline. The Nigella Lawson Standard, and what it reveals about the system. I keep coming back to Nigella Lawson. Not because she's the most important person in this story, but because she is the clearest illustration of what the law is supposed to look like when it applies equally. In 2013, she admitted in open court, under compulsion, not for profit, not in a best-selling memoir, that she had taken cocaine and marijuana. She didn't write a book about it. She didn't give a 60 Minutes interview about it. She didn't record an audiobook of herself describing it. She admitted it, involuntarily, in a legal proceeding. The following year, she showed up at an airport to board a flight to Los Angeles. They turned her away at the gate. Not at border control. At the gate. They had already been informed. They had already made the decision before she got on the plane. She spent months fighting through formal waiver applications, multiple submissions, formal processes. She was eventually allowed back in, but only after the full machinery of American immigration law had processed her case at its normal speed. That's the standard. That's the baseline. That's what the law says is supposed to happen. Harry admitted cocaine, mushrooms, marijuana, ayahuasca, in Britain, on American soil, across multiple decades, across multiple jurisdictions, in his own words, in a book, on television, on a global promotional tour, he walked through in 14 days. Niall Gardner, Yale doctorate, former aide to Margaret Thatcher, director of the Margaret Thatcher Center for Freedom, named one of the 50 most influential Britons in America, has been making this point in federal testimony, in congressional briefings, in over 500 television interviews. Americans deserve to know if Prince Harry lied on his application and DHS looked the other way. No third option exists. Either he lied, in which case it's a federal crime, or he was treated differently, in which case it's an institutional scandal. Both outcomes are, to use Gardner's framing, scandals. Only one of them is a crime. And there are real people whose lives this question matters to. Not theoretically, concretely. Every person who has ever been turned away from a U.S. border for drug disclosures. Every immigrant who sat in front of a consular officer, answered those questions honestly, disclosed something they'd done years ago, and watched the door close. Those people don't get to frame their drug use as radical vulnerability. They don't get a documentary about their brave confrontation with their past. They don't get a Netflix deal about their exile. They get a no. They go home. Some of them never get back in. The law is supposed to apply to everyone. That's not a political statement. That's the foundational premise of every legal system in the democratic world. And when the evidence suggests it may not have applied equally in this case, the public has a right to know why. The financial collapse. Runway measured in years, not decades. Now let's talk about money. Because the visa case doesn't exist in a vacuum. It exists inside a financial picture that has been deteriorating in ways that make the legal exposure exponentially more consequential. Business analyst Hilary Ford's forensic assessment of Sussex finances puts current net worth at approximately $35 million, down from a peak of around $60 million. That's a $25 million decline from their own high point. The Montecito mansion, the one they window shopped for in July 2020, carries monthly mortgage payments estimated at around $100,000, annual property taxes of $280,000. Security costs, privately funded since they lost Crown protection, running at between $4 and $5 million per year. That's one line item. Security alone, $4 to $5 million a year. The Better Up partnership, reportedly worth several million dollars, appears to have concluded. The Spotify deal was terminated, and not quietly. An executive at the company publicly described them in terms I can't repeat, which made headlines globally. The Netflix Polo documentary was canceled. Public speaking fees, once reported at around $1 million per appearance, have reportedly collapsed to approximately $50,000. Here's the detail on that last number that tells you everything about where things stand. Business author Jim Collins, who wrote a management textbook called Good to Great, was reportedly charging $60,000 per speaking engagement with a 6-month waiting list. The son of the King of England is being outbid for speaking slots by someone who wrote a book about spreadsheet management. That's not a footnote. That's a verdict on brand value. Now put the legal costs on top of all of that. Cumulative legal fees across the Heritage Foundation visa litigation, the UK security challenge, the phone hacking claims, the Sandringham Flower Show dispute. Estimates across multiple cases reach approximately $38 million. $38 million in cumulative legal fees, against a current net worth of $35 million. The mathematics of that do not work. They simply don't work. And that's before June 12th. Because if those 2,487 pages unseal and they show that Harry's answers on his visa application contradict his published memoir, and it is genuinely difficult to construct a scenario where they don't, given that the memoir is a multi-hundred-page confession to conduct that the immigration form directly asks about, the consequences are not theoretical. Under the Immigration and Nationality Act, Section 212A(6)(c)(I), material misrepresentation on a visa application creates a permanent bar from the United States, not a fine, not a suspension, not a reapply in 5 years. Permanent. Under 18 U.S.C. Section 1001, making false statements to a federal agency, it's a maximum 5-year prison sentence. There is no royal exemption in Title 18 of the United States Code. There is no footnote that reads, unless your grandfather was a king. Samuel Dewey said it clearly outside the courthouse. People are routinely deported for lying on immigration forms. Routinely. Harry is not a routine case, but the law he may have violated is identical to the one that routinely removes people who did a fraction of what he has publicly admitted. The two boxes, and why neither one saves him. Here's where we arrive. After everything, the timelines, the financial declarations, the mushrooms in Los Angeles, the redacted pages, the Nigella Lawson comparison, the $38 million legal bill against a $35 million net worth, we arrive at the simplest possible summary of this case. There were two boxes on the form, yes and no. Have you ever violated any law relating to controlled substances? Yes or no. There is no third box. There is no box that reads, yes, but I was a duke, so I assumed different rules applied. There is no box that reads, technically yes, but the book wasn't published yet, so perhaps we can treat this as hypothetical. There is no box that reads, I'd prefer not to say, and I'd like 6 years and $38 million in legal fees to keep that preference intact. Yes or no. If the documents unseal and show that Harry answered yes, that he disclosed the cocaine, the mushrooms, the marijuana, the ayahuasca, the Courtney Cox party, then there is a different, equally significant question. Why did the U.S. government approve him in 14 days? Why did the department that turned Nigella Lawson away at a gate process a man with a far longer and more serious history in 2 weeks? What conversations happened? What decisions were made? And by whom? That outcome is not good for Harry. But it's also not good for the Department of Homeland Security. If the documents unseal and show that Harry answered no, that he sat in front of that form, knew precisely what he'd done, knew precisely what he'd eventually write about and sell for tens of millions, and checked the box marked no, then we're in different territory entirely. Then the man who built a $135 million brand on radical honesty, on speaking truth to power, on vulnerability as a virtue, on telling the world things the palace didn't want told. That man committed federal fraud on his immigration application. And the entire architecture of the Sussex brand collapses on its own foundations. Because those are the only two boxes, and in a matter of days, we find out which one he checked. I suspect, based on 6 years of litigation, tens of millions in legal fees, aggressive redactions, convenient deadline delays, and the frantic machinery of 2 governments and 1 royal family trying to keep a file sealed, that he already knows which answer can't survive sunlight. What happens next? Let me be precise about what June 12th actually means. It doesn't mean Harry gets deported on June 13th. It doesn't mean charges are filed automatically. It doesn't mean a perp walk and a headline and credits rolling. What it means is that the public, for the first time, will have access to the documentation that shows what he told the U.S. government he was in March 2020. And then the lawyers, the journalists, the legal analysts, the immigration specialists, and frankly anyone with a copy of Spare and an hour to spare will be able to sit down and compare those two things side by side. The memoir versus the declaration. The published confession versus the sworn form. The man who sold his story versus the man who had to legally define that story to a federal agency. Niall Gardner, who has been building this case methodically through congressional testimony, federal court filings, and 3 years of precise legal advocacy, has been patient. He's been deliberate. He's been doing it one deadline at a time. He either gets the documents that prove the discrepancy, in which case deportation proceedings become a genuine legal conversation, or he gets documents so aggressively redacted that the cover-up itself becomes the front page, a cover-up that implicates not just Harry, but the Department of Homeland Security, the State Department, and potentially decisions made at the highest levels of the previous administration. Both outcomes are bad for Harry. Both outcomes are significant for the public. And both outcomes sit on top of a financial structure that, by independent analysis, has a runway measured not in decades, not even in a single decade, but in years. Here is what I want you to answer in the comments. And I want you to genuinely think about it. Not the political version of the answer, not the tribal version, the actual analytical version. If those 2,487 pages show that Harry told the truth, that he disclosed every drug, every incident, every laughing trash can in Los Angeles, what does it tell us about the United States government that they approved him in 14 days, while Nigella Lawson spent months on the wrong side of a departure gate? And if the documents show he answered no, if he sat in front of that form and checked the box that said he had never violated any controlled substance law, knowing exactly what he'd done and what he'd one day publish? What happens to the man who built an empire on the claim that he always tells the truth? Those are the only two questions. And they have been the only two questions for 6 years. On June 12th, we get the answer. Subscribe if you want to be here when we read it, because this channel will be going through every page, every date, every declaration, and every number. No PR teams, no diplomatic hedging, no commercial relationships with any royal camp on either side. Just the documents, and the questions they've spent 6 years and $38 million trying to prevent you from asking.